Hello everybody and welcome to our first lesson in the study of criminal evidence. This is the first of a brand new series of lessons covering all of the basic features of the law of evidence within the jurisdiction of England and Wales. And just like with the lessons that I've done on and in relation to company law and family law, I'm just going to get a few points off the, at least at the start right now, a few changes that are going to be made going forward as a result of a number of changes that I thought would be quite important. The first of these changes is recognizing the fact that fundamentally these lessons are being made and being recorded and being released for members only as early as June 2023, but that the lessons themselves won't be released to the public until the start of the new year in June 2024, it starts the new year in 2025. The reason for this is because we've been scheduling lessons in the future, and also to give time for people who are members only to get free and early access to that content before everybody else. But the result of that is, of course, that you are going to be watching lessons which are outdated fundamentally, or could potentially be outdated theoretically. And so as a result of which, I've started this practice of having a little date down here on the corner. This date refers to the date at which this lesson was recorded. So it was recorded on the 25th of June 2024. And that's just to ensure that for those of you who are watching this when it releases to the public more broadly in 2025, or even if you're in 2026, 2027, 2030, and you are going back and looking at these lessons, you have an idea of when this video was released, just to get a snapshot of the law that was up to date, at least at the time of recording these lessons. Now, fundamentally, there is a little bit of an exaggeration about how much law changes from year to year. Generally speaking, if you record a lesson in 2024, the vast majority of the principles and the vast majority of the case law will remain good law for a good few years, and in some cases will remain good law for basically indefinitely. So there isn't too much of a worry to be had about the sort of future proof of these lessons, how future proof they are, but generally speaking, it's always good to just have a general idea of when this lesson was recorded. That's the first point. The second point is that this is going to be one of three topics that we're covering now that we have finished the lessons on the core modules. We've done all the core modules, as well as as well as the English legal system, as well as a series of lessons on jurisprudence. Now we're going to be covering, for the year of 2025, we're going to be covering family law, company law, and criminal evidence law. And then finally, what I've done is, at the end of every single lesson, is included and introduced a bibliography, which includes our citations as well as further readings for these lessons. They are more general in terms of their further readings, but I will also be putting together a Substack post, which essentially formulates a big old collection of videos and a collection of readings, of journal articles, of book chapters for each of these topics as well, so that you have a very, very in-depth and detailed look at the kinds of things that you could be doing in terms of further reading. That'll be released, I'm not sure entirely when it'll be released, but they'll be released for each and every single module, including the core modules that we have already done. So, with all that being said, let us actually get into the subject of this lesson. This is the first lesson in a new series on the study of criminal evidence law. This lesson specifically is going to take an introduction to the subjects, as well as outline a number of key features of criminal evidence law, before essentially defining the scope of inquiry over the next few lessons. The sort of scope of of these lessons is slightly in flux, in the sense that I'm still working out where some of the things are going to go and how much emphasis I'm going to give to some topics over other topics. But a general template of what this series of lessons is going to look like is available at the end of this video. So there won't be too many changes, presumably. Let's get an introduction to what criminal evidence law actually is. The law of evidence, in fact, can sometimes be delineated between the concept of criminal evidence on the one hand and civil evidence on the other. This is actually something that we're going to be doing here. We're going to be focusing mainly on evidence and the procedure of evidence from the criminal law perspective, the way in which the criminal law codifies and solidifies the concepts of evidence. This is obviously meaning that we will not be spending any, if at all, any time focusing on the concept of the civil evidence rules. So just, this is essentially, treat this and think of this as if you are somebody who has watched all of the lessons that I've done on criminal law, and you want to go into a bit more detail on the elements of the criminal law that exists in England and Wales. Criminal evidence law is the sort of natural follow-on, the natural sequel to basic criminal law that you have studied and that you will be required to study if you are doing a law degree. This is not necessarily the case, however, with every single textbook. Some textbooks often just combine the two jurisdictions into a sort of broader law of evidence. We're trying to delineate these two apart from each other, so bear that in mind when we think about this. We're talking about the concept of which evidence is adduced, evidence is presented, evidence rules are created within the context of the adversarial trial, the context of the jury trial in the criminal jurisdiction. So, the law of evidence itself is something of a particularly unique common law tradition. It comes directly out of the development of the common law itself. And so for this reason, it can be argued that the law of evidence is more or less exclusive to that of the common law. At least basic principles of the law of evidence as codified and as encapsulated by the common law. The reason why I say here, by the way, more or less, as cited here on the screen, is because there has been movement on the ways in which certain principles of the law of evidence have been able to extrapolate out of the common law and into some of the more continental civil law traditions, especially when it comes to sort of jurisprudence that relates to evidentiary principles around Article 6 of the European Convention on Human Rights, obviously, which is, of course, the right to a fair trial. If you want to know more about that, go and see our lessons on the European Law Academy, which covers the European Convention on Human Rights, or stay tuned for this series of lessons where we will talk about the right to a fair trial and the ways in which this is encapsulated in both Article 6 of the Convention, as well as, obviously, provisions within the Human Rights Act. So what is the origins of evidence law then? If this is a common law tradition, it has to at least have existed from time immemorial, which is of course the date at which we describe the beginning of the common law, the ascension of Richard the First, to the throne. But where is the true origins of evidence law? Well, unfortunately for us, and unfortunately for common lawyers, it is not entirely clear where we see a beginning point, the starting point for all of the rules of evidence. There's not like this sort of codification of the rules of evidence in a similar sense that exists when we talk about, for example, continental traditions. It is generally believed that the development of evidence rules coincided with the development of the basic common law adversarial trial system that we have in our jurisdiction. The main feature of the common law system, at least when it comes to criminal jurisdictions, is this idea of the adversarial nature of a jury trial. The prosecution will present a case to a defendant. The defendant then has legal representation to rebut and to challenge these claims. This is obviously the case, assuming that a defendant is not acting as a, quote, litigant in person, not acting as essentially their own litigation and their own legal counsel, which of course is quite a bad idea if you are somebody who is looking to seek to defend themselves. Then, from here, we have a jury that will make a determination as to the guilt or lack thereof of a defendant. And as this adversarial system begins to develop, it in fact doesn't develop for quite a while. Some people suggest that the trial and the concept of the jury trial existed from very, very many years ago. In fact, that wasn't the case. You would have other systems which existed prior to this development. But when and as these rules of the adversarial trial system begins to develop, so too comes the development of a number of rules of evidence. Namely, and really where we begin ourselves with ourselves on evidence, is the idea of exclusionary rules of evidence. Rules of evidence which pertains to the kinds of evidence, the kind of information, the kind of fact-finding that you may or may not be able to do in relation to a jury trial. The type of evidence which may or may not be excluded at trial, which may or may not be, as the key term is cited, admissible at trial. So really, when it comes to this basic notion here, is that we see that there is quite a lot of importance that is assigned to the concept of the jury trial and the concept of evidence in the jury trial. A theory presented by some legal philosophers suggests that the nature of the jury trial, the determination of guilt being made by a layperson, necessitates the existence of rules of evidence. So you can't necessarily have the jury trial without having particular rules that relate to evidence. That is the basic theory. Why is that the case? Well, because as cited here, the jury is determining the guilt or not guilt, the lack thereof of guilt of a particular defendant, but the jury represents a layperson, and so they necessarily require there to be the existence of evidence rules so as to not have to go into the sort of determination of what is good evidence, what is bad evidence, what is evidence that would bias a jury and what may not bias a jury. Essentially, according to Munday, it is suggested here that evidence protects people from evidence that could, evidence rule, should I say, protects people from evidence that might prejudice or inflame them, and which might prejudice a jury, and which might not actually lead to a just, fair end to a particular trial. It might enter the guilt of an individual on the basis of elements that are not down to the basic fact-finding mission of the jury trial. So this is one of the reasons why evidence may be particularly interesting and particularly important, and maybe even a necessary feature of the jury trial. Now, what is important to note here, as well as this, is that fundamentally, when we are talking about evidence and evidence rules, there are various different conceptualizations, various different complicated rules on the jury trial, on presumption of innocence, on things like hearsay rules, things like that, the exclusion of bad character evidence, and all this kind of stuff. And fundamentally, what these rules boil down to is the extent to which certain evidence may or may not be admissible, may or may not be heard at trial and heard by a jury. And really that sort of underpins and is the foundations of all of evidence law. And so, which is really why we're going to be talking about, for the beginning, the key principles, the concept of admissibility on the one hand and relevance on the other. We will then also talk about the concept of burdens and presumptions, the burden of proof being on the prosecution in a number of cases, and the idea that there is a basic presumption of innocence, sometimes described as the golden thread rule, if we take reference to the case of Wilmington versus the Director of Public Prosecutions, a case that you will have studied if you have followed my lessons on the criminal law. We will then start talking about character evidence, things like the hearsay rule. We'll talk about the basic structure and the course of the jury trial. We'll talk about things like the opinion rule, and in terms of members-only content, we're going to be doing some extra lessons, some sort of 20 or so extra lessons, which deal with some more advanced elements of criminal evidence. The idea of character and credibility, the idea of competence and compellability, the idea of evidence which is improperly obtained, as well as this idea of public interest immunity. Now, like I've said, and like I said at the start of this lesson, this may not be the sort of final structure of this series of videos. As I'm working through this series of videos, I might change things around here and there, but this is fundamentally a basic first draft of what the structure of this series of lessons is going to entail. And finally, we'll talk about privilege. This is the bibliography and further reading that you're going to see at the end of every single one of these lessons. These are all textbooks and revision guides, fundamentally. The more advanced series of further readings that I'm going to be unpacking for people on the Substack post is going to include very, very specific elements of evidence law that is not covered on this particular slide. For the most part, the core text series from Monday is going to be a very, very, very important resource for people, as well as Spencer and Spencer's Concentrate, which is obviously just a nice revision guide on the law of evidence. more in more detail of that, we've obviously got Doak, Dennis. We've also got Keane and McKeown. You've got Roberts and Zuckerman, all of which are very, very important texts on the subject of evidence law. The most recent of which being the Modern Law of Evidence, the 15th edition from Keane and McKeown from 2024.